recording in progress.
Okay, gonna start. Everyone.
This meeting is being recorded.
Wednesday, the 31st of March, 2021, Court Commercial Court 1 via Zoom at 10:02 a.m. before the Honorable Chief Justice, Civil Jurisdiction 2019, number 92, the Corporation of Hamilton versus the Attorney General and the Governor of Bermuda, Mr. Dill for the applicant, Mr. Howard for the respondents.
Yes, good morning.
Morning, my lord.
Morning, my lord.
Morning.
I think you have to turn off your volume. I have, as promised, prepared a judgment in this matter, which, as you know, I have circulated to you for editorial comments. I have taken those comments into account. I should say that I've also made some further minor changes to 3 or 4 paragraphs. So it's important that you should discard the draft that you have and going forward only utilize the judgment which is being handed down this morning. The judgment for purposes of delivery, as you know, is divided into sections. Section A deals with introduction, section B deals with the background. The background is divided into historical background, voting in municipal elections, wharfage levy, the Democracy Trust, the Parleville Hotel development, and then section C deals with amendment acts and the bill. Section D deals with the constitutional provisions. Section E is then discussion in relation to the issues which are raised, specifically with the direct enforceability of section 1. Secondly, the enforceability of protection of law provision. And thirdly, the breach of section 13(1) of the Constitution. And then section 5 is the conclusion. So before handing down the judgment, I'll refer to some of the passages which summarize the main points of the judgment. At paragraph 6 of the judgment, I say the proposed Reform Act is controversial and has generated highly emotive debate in the community. Indeed, in the written submissions filed on behalf of the corporation, the court is asked to conclude that the legislative proposals are irrational, arbitrary, and unfair. In considering this application, the court reminds itself of the separation of powers between the legislature, the executive, and the judiciary enshrined in the Constitution. The responsibility for considering, debating, and passing legislation, such as the proposed Reform Act, lies solely with the legislature. In the ordinary case, the courts do not express any opinion in relation to the merits or wisdom of adopting a particular legislative measure. The practice of self-restraint on the part of the judicial branch is of long standing and continues to be relevant to this day. Accordingly, this court is only concerned with the legal challenge to the Amendment Acts and the proposed Reform Act, and in particular, in relation to the legal issues, whether the Amendment Acts and the proposed Reform Act are in breach of constitutional rights of the corporation relating to 1, the protection of law under section 1, and 2, deprivation of property under section 13, subsection 1. Beyond these legal issues, it would not be proper for this court to express any view as to the merits of the Amendment Acts and the proposed Reform Act. The merits of the Amendment Acts and the proposed Reform Act are matters of political debate and are to be debated and decided upon by the legislature. Beyond the determination of legal issues arising out of the alleged breaches of Section 1 and Section 13 of the Constitution, the merits of the Amendment Acts and the proposed Reform Act are not the proper subject matter of a judicial determination. Then at paragraph 42, I say the corporation contends that over its long history, it has performed well in providing municipal services to the inhabitants and business owners in the city of Hamilton, and that it should be allowed to carry on providing those services independent of the central government. The government, on the other hand, contends that the authority devolved to the municipality is a matter for the central government. The government points out that, unlike the local government in other jurisdictions, the corporation's responsibilities are limited to infrastructure. The Attorney General contends that the government's policy aim in the amendments since the 2010 Reform Act has been to increase accountability, reduce expenditure for city residents, consolidate scarce resources, and modernize taxation. The Attorney General further contends that the government's policy objective of harmonizing services and facilitating the sharing of resources has been made very difficult to implement as a result of the resistance by the corporation. These conflicting views form the essential backdrop to the present constitutional challenge by the corporation to the proposed legislation by the government. And then I deal with the facts which are relied upon by the corporation in support of the constitutional challenge. I will not read all of them, but simply to give you some idea, it is said by the corporation that the minister or his representative is entitled to participate in all the corporation's deliberations in relation to any matter. The corporation cannot make any decision without a resolution, and every resolution requires the minister's approval in writing. In relation to the disposition of land, even after the minister has had the opportunity to participate in the deliberations and has approved the resolution, the corporation must submit a draft of any agreement to sell or lease it for a period exceeding 21 years to the minister for cabinet approval, and the approval of the legislature must be obtained. And then all of the corporation's powers, functions, or activities are qualified by the minister's overarching power to approve or disapprove of its exercise. In the event that the minister believes that there has been mismanagement of the corporation's affairs, the minister has the power to assume control of the corporation entirely, including of its financial governance and overall governance, for an indefinite and undefined period, which comes to an end only when the minister is satisfied that such control is no longer necessary. And then in relation to the proposed legislation, the corporation says the proposed legislation leaves all these controls in place and seeks to abolish municipal elections and replace elected members of the corporation with members appointed by the minister, either himself or through a selection committee appointed by him. If the bill is enacted, therefore, the corporation contends the government will not only control the corporation's functions, powers, activities, and finances, but will also be in a position to appoint persons to the corporations who are thought to be likely to support the government's agenda. The corporation will, in effect, become part of the government, and the government will have control over its assets. And then, so the judgment is understood in this context. The legal issues which are raised in this challenge are the following. A, does Section 1 of the Constitution have independent force and therefore is directly enforceable regardless of the provisions of the remaining substantive sections? B, if Section 1 as a whole is not directly enforceable, is the provision relating to protection of law contained in Section 1A nevertheless directly enforceable? Thirdly, what is the scope of protection of law provision contained in Section 1A? Fourthly, if the protection of law provision is directly enforceable, is the government in breach of this provision? And E, what is the proper scope of Section 13(1) of the Constitution? And in particular, What is the proper meaning of the expression shall be taken possession of, and no interest in or right over property of any description shall be compulsorily required? Secondly, can they be taken by regulatory control exerted by central government over the corporation? And if so, what is essential nature and quality of that control? And final question is the government in breach of Section 13(1) by exerting control over the corporation as alleged by it? Then there's a long section dealing with is Section 1 directly enforceable, starting at paragraph 46. And the concluding paragraphs are paragraph 75 and 76. At paragraph 75, I say, in my judgment, the Privy Council in the passage cited above was not adopting the Nervais holding that whereas provision in the Constitution was intended to have independent force and was directly enforceable. If that was indeed the position, it would be a reversal of the Privy Council's earlier decision in Campbell Rodriguez and the Attorney General and Newbold and Commissioner of Police. And yet these decisions are not referred to in the judgment of the Privy Council. At paragraph 76, I say, in the circumstances, I conclude that the court is bound to follow the decisions of the Court of Appeal in Great Bay, Inchcup, and Ferguson in relation to the issue whether Section 1 of the Constitution is directly enforceable, and is bound to accept the position that Section 1 does not provide the corporation with a freestanding right. And I say I accept that, assuming the court is not bound by earlier decision, a case can be made as to why the Bermuda court should adopt the more expansive interpretation of Section 1 for the reasons given by the Caribbean Court of Justice in the Nervais case. However, it seems to me that given the decisions of the Court of Appeal in Great Bay, Inchcup, and Ferguson, such a challenge in law can only be made by the Privy Council. Then I deal with the second main issue, is the protection of law provision nevertheless directly enforceable? And to place that issue in context, the corporation argues that even if the court determines that Section 1 is not directly enforceable in its entirety, there is a specific line of authority which treats that particular right as a separately enforceable, whether or not remainder of the Section 1 may be. The corporation relies upon the Privy Council decision in Lewis and the Attorney General, Newbold and the Commissioner of Police, and Jamaicans for Justice against the Police Service Commission. I deal with that issue and at paragraph 85, I say, I accept, in accordance with the reasoning of Lady Hale in Nervais, that the concept of protection of law is wider in scope than the terms of Section 6 of the Bermuda Constitution, and accept that it affords every person protection against irrationality, unreasonableness, fundamental unfairness, and the arbitrary exercise of power. Then I refer to some of the cases. At paragraph 89, I say, it can be seen that all these cases involved a challenge against a decision of public officials or public body on grounds that the decision was irrational, unreasonable, fundamentally unfair, or otherwise was an arbitrary exercise of power. The challenge in the present case is not a challenge to a decision of public official or public body, but to the proposed action by the Bermuda legislature. It is not clear how, if at all, the expanded scope of the right to the protection of law, as accepted in cases such as Jamaicans for Justice, applies to the legislative process, in particular whether an act of the Bermuda legislature, duly assented to by the governor, can be set aside by a court on the ground that the legislation was irrational, unreasonable, unfair, or constituted arbitrary exercise of power. It is, of course, accepted that an act which infringes the fundamental rights and freedoms set out in sections 2 to 13 of the Bermuda Constitution, which includes the fundamental right to the protection of law in section 6, can be modified or set aside by the court. However, the submission that an act of the Bermuda legislature, which is not in breach of any of the fundamental rights and freedoms set out in sections 2 to 13, can be set aside by the court on grounds of irrationality, unreasonableness, unfairness, or arbitrary exercise of power is, in my judgment, contrary to the long-standing position as to the respective roles of the judiciary and the legislature. Then at paragraph 95, I say, In my judgment, the issues raised by the corporation as to whether there has been an adequate consultation by the government, whether the City of Hamilton is well run, whether governmental interference has been unhelpful and counterproductive, whether the general public is in favour of maintaining the status quo, and whether the proposed legislation is arbitrary or unfair exercise of power without rationale or compensating benefits to the public interest, are all issues which belong to the realm of politics and public debate, and are not a proper subject matter of judicial determination, save to the extent they constitute a breach of the corporation's fundamental rights enshrined in sections 2 to 13 of the Constitution. And at paragraph 97, I conclude, for the reasons set out above, I am unable to accept the submission that there has been a breach of the right or right to the protection of law referred to in section 1 of the Constitution, and as a result, the court should declare that the proposed Reform Act and the Amendment Acts are void and of no effect. Then I turn to, at paragraph 98, the issue under section 13.1 as to whether there's been deprivation of property under section 13.1 of the Constitution. And section 13, subsection 1 provides that no property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired, except in the circumstances set out in sections A to D. I deal with that issue in the following paragraphs, and at paragraph 115, I say, in my judgment, Panton, that's the Privy Council decision in Panton, which is binding on this court, is authority for the proposition that mere loss of control, even total loss of control, does not amount to deprivation of property. There must be taking by reference to the loss in the value of identifiable property. This was the basis upon which the Privy Council distinguished the decision in the Court of Appeal in Lawrence. Here, the corporation as a legal entity continues to own the assets as before, and there is no suggestion that there has been any diminution in value of those assets. At paragraph 120, I conclude, the corporation's challenge based upon deprivation of property, contrary to the constitutional right under section 13, subsection 1 of the Constitution, is based entirely on the basis of control exerted by the central government over the affairs of the corporation. The corporation accepts that this is not a case where there has been any transfer of property from the corporation to the government. The Privy Council decision in Panton clearly holds that the assumption of management control without more does not amount to deprivation of property. Significantly, the Privy Council in Panton distinguished Lawrence, the main case relied upon by the corporation, on the basis that the loss of property in that case could be identified, loss of up to 50% of the dividend from the bank. In the circumstances, I am satisfied that the corporation's challenge based upon section 13.1 of the Constitution cannot succeed. And then my conclusion is set out at paragraphs 129 and 130. And paragraph 129, I say, the proposed legislation by the government has generated highly emotive debate. In these proceedings, the corporation has charged the government that its legislative proposals concerning the municipal corporations are irrational, arbitrary, and unfair. The court reminds itself that its jurisdiction in relation to acts of parliament and proposed legislation is limited to considering whether the legislation infringes fundamental rights and freedoms set out in sections 2 to 13 of the Bermuda Constitution. Beyond that, the merits of legislation belong to the realm of politics and are not the proper subject matter of judicial determinations. And at paragraph 130, in relation to the constitutional challenge pursued by the corporation, the court has concluded, 1. Section 1 of the Bermuda Constitution does not have independent force and therefore is not directly enforceable by the corporation. 2. Whilst the court takes the view that the right to protection of law at common law is wider than the terms of section 6 of the Bermuda Constitution, the court dismisses the corporation's claim that in the circumstances of this case, there has been a breach of the right to protection of law. Thirdly, the court dismisses the corporation's claim that having regard to the control exerted by the government over the corporation under the Amendment Acts and to be exerted under the proposed Reform Act, the government has deprived the corporation of its property under Section 13, subsection 1 of the Bermuda Constitution. Fourthly, the corporation's claim for a declaration that the Amendment Acts and the proposed Reform Act be declared null and void is dismissed. And the only remaining issue is that of the costs of these proceedings. That is the judgment which I will now hand down and which I have signed. So the judgment is formally handed down. There is the issue of costs. Do I understand we're going to deal with the issue of costs now or at some other stage?
My Lord, Mr. Deal we'd ask for a cost. Mr. Deal has submissions on the matter, so we can submit dates to the court to argue that point if the court believes it necessary.
I think I've just received your submissions, Mr. Deal, and the cases. You raise an interesting point. It might be worthwhile having a short separate hearing in relation to that, if that is acceptable to the parties.
Yes, my lord. In fact, I'm grateful to both my friend and your lordship. That would be my suggestion. Yes.
So we will adjourn the issue of costs, which the Attorney General makes an application for cost, and we'll consider that at a separate hearing. Unless there's anything further, so the judgment has been handed down. Unless, as I say, unless there's anything further, this hearing is now concluded.
Thank you, my lord.
Thank you, my lord.